United Steelworkers of America v. Weber, 1979. Companies can implement affirmative action programs. United Steelworkers of America v. Weber, 1979 was a case which reached the Supreme Court on appeal, with the finding being made that companies had the right to implement an affirmative action program for a training program which reserved half of its spaces for African Americans until a time when the percent of skilled African American trade workers matched the percent of the surrounding community, a change from a current 2% to match a 39% of the community. More specifically, the court found that such a program did not violate Title VII of the Civil Rights Act of 1964. Brian Weber had sued the United Steelworkers of America because it supported a Kaiser Aluminum and Chemical Corp policy of allowing African American and white workers into the training program at a one-to-one basis, even though there were many more whites. Completing the training program resulted in higher pay, and Brian Weber had more seniority than many of the African Americans who were admitted to the training program. The Supreme Court reversed the decision of lower courts and ruled against Brian Weber. The ruling established that companies had the right to reverse the effects of discrimination through affirmative action programs. Multiple choice question. United Steelworkers of America v. Weber, 1979. A. Companies can implement affirmative action programs. B. One-to-one, minority to non-minority, if fair by the numbers. C. Pre-employment tests must be predictive for the job. D. Affirmative action is almost always reverse discrimination. Well, the correct answer choice from what we've been given here for United Steelworkers of America v. Weber, 1979 is A. Companies can implement affirmative action programs.